Good afternoon again, and welcome to this Legal Aid New South Wales webinar on what's new with Section 32, mental health and cognitive impairment in the local and children's courts. My name is Kerry Wright, and I work in the Community Legal Education branch at Legal Aid New South Wales. I'm here today with Jane Sanders from the Shopfront Youth Legal Service. Hi, Jane.
Hi, Kerry. Hi, everybody.
So to begin, we would like to acknowledge the traditional owners of this land. We would also like to pay respect to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending today or watching the recording. So the purpose of this webinar is to explain the changes to the law that from 27th of March 2021, the Mental Health and Cognitive Impairment Forensic Provisions Act 2020 came into effect. So Jane, can you introduce yourself to our audience and tell us a bit about the Shopfront?
Sure. So I am the principal solicitor of the Shopfront Youth Legal Centre, which is a free legal service for homeless and disadvantaged young people aged 25 and under. A lot of you who are watching or listening today are probably familiar with the Shopfront and have worked with us over the years. The Shopfront is located in Darlinghurst on Gadigal land. I'm coming to you today also from my home, also on beautiful Gadigal country. And I just echo Kerry in acknowledging the traditional owners of the land and paying respects to their elders, past, present and emerging. The Shopfront, as we work with a lot of young people experiencing homelessness, our clients have quite significant trauma histories. A lot of them have mental health issues or cognitive impairments. So our lawyers are in court all the time running what we used to know as Section 32 applications, what are now being called Section 14 applications. So that's where I'm coming from, and I hope that I can give you a really good practical overview of the law today. Thanks.
Fantastic. Thanks, Jane. So the slide that's coming up now is just an overview of what we will cover today. So what is the new law and what does it replace? Criminal matters involving people with mental health and cognitive impairment, diversionary procedures in the local and children's courts, how community workers can help, and answering your questions. And just a reminder, because quite a few people have joined us since I first started, and just to say that there's a couple of handouts on your GoToWebinar control panel. You can download those now and keep those as a resource, plus you'll get the email after the webinar. Okay, so Jane, can you first of all explain to us the change to the law and why we needed this new act?
All right. Maybe I'll start with the second question, why we need a new act. That's quite a difficult question, actually. But the old Mental Health Forensic Provisions Act has been around since 1990, as well as dealing with diversionary procedures in local courts, which you might be familiar with, Section 32 and Section 33. It has a whole lot of procedures that apply in higher courts as well. So for people charged with serious offences going to the district and Supreme Courts, has a whole regime about dealing with people who might be unfit to be tried, or people who may be pleading not guilty by reason of mental impairment. It's got procedures for people being made forensic patients and being reviewed by the Mental Health Review Tribunal, etc., etc. So a lot of those procedures, which are not going to be the subject of this webinar and with which I'm not very familiar anyway, a lot of those procedures were getting a bit outdated and clunky and were thought to be in need of review. There were also some, with the diversionary provisions, the Section 32 and 33, there was also some movement for change to those as well. Now, back in 2012 and 2013, the New South Wales Law Reform Commission released a series of reports with recommendations about changing the law on mental health, people with mental health and cognitive impairments in the criminal justice system. Those recommendations were made after very extensive consultations, and the recommendations, well, they sat there. Maybe they didn't sit on the shelf entirely, but it took something like 7 years for the Department of Justice in New South Wales to really consider those recommendations and to look at some legislative change. Now, there have been some, I think, more significant changes to the procedures that apply in higher courts in relation to what I'm going to talk to you about today, which is the diversionary procedures in local and children's courts. Hardly anything has changed. There's been some changes to definitions. There's been a little bit of tweaking, but basically it's very much the same. I think I can tell you, without letting you in on too many secrets, that there certainly was a proposal, or there were people talking about some more radical changes to the Section 32, 33 type procedure. Unfortunately, those changes would have required more resources put in place, actually services being funded with a actual legal role and legal mandate to supervise these orders, to do reports, to come up with case plans. Now, often, unfortunately, all the best ideas founder because of lack of resources or lack of commitment by government to resource things properly. So the changes to the law ended up being a very minimalist model, and you'll probably find that the most significant changes are that everything's been renumbered. But other than the renumbering, there's very, very little has changed.
Okay, thanks, Jane. Someone asked a question, are any of these laws specific to children, or are they general for all? No, they're general. Okay.
Yes.
All right. Okay, well, what we thought we'd do now is to have a quick poll just to get a sense of who has worked with these laws. So I'm going to launch that poll now for our audience. So that's coming up now. Have you supported a client with a Section 32 application, yes or no? So we'll just let people take some time to answer that question. People are worked out how to vote on that. So I think I'll close that. Majority of people seem to have voted. So I'll close that and share the results with Jane. They should be coming up now. So you'll see there nearly 60% said no, but 40% said yes. So we've got quite a good mix of people in the audience today. So that's good to know that we have had, 40% of our audience today have had some experience with that. Okay, so we'll move forward then. Our next slide is just for you, Jane, to give us an overview of diversionary provisions and why these are important for people with mental health and cognitive impairment.
Okay, so as most people would know, if you're charged with a criminal offence and you're going to court, usually the court will require you to enter a plea, and that plea is usually going to be either guilty or not guilty. And if you plead guilty, the matter usually proceeds to sentence either on the same day or another day, and the court imposes a penalty, which could be a fine, it could be a good behaviour bond type order. The extreme end, it could involve imprisonment for some offences. If you plead not guilty, then the case will go to hearing and witnesses have to come along and give evidence and answer questions, and then the magistrate decides whether they believe the charge is proven beyond reasonable doubt. Now, for people who have cognitive impairments or mental health problems, they might find a lot of those processes very, very difficult. At the extreme end, you might have someone with quite a significant cognitive impairment who simply doesn't understand enough about the court process to be able to properly participate, or even to understand the difference between guilty and not guilty, and what a plea is. You might have people who understand that but are going to find it very, very difficult to defend their charges, because it's going to be hard for them to get up in the witness box, to give evidence, to answer questions, to even remember what happened, because they might have been acutely psychotic at the time of the alleged offence, for example. Or there might be situations where the person, for example, if they were in a psychosis at the time of the alleged offence, they might have actually done the deed, but they're not criminally responsible because they just did not have the understanding of what they were doing, or their conduct wasn't voluntary. So for all of those reasons, it might be inappropriate to expect someone to make a plea and deal with things in the normal way. It might be unreasonable to punish someone with a criminal record and a criminal type punishment if they were not truly criminally responsible for their actions. Or even if they do understand, even if they, yes, could have been criminally responsible, they may not, people with cognitive impairments particularly, they may not deal very well with conventional criminal punishments, particularly imprisonment, things like fines, even things like good behaviour bonds, community correction orders, conditional release orders. With those kinds of things, they might actually find it quite difficult to comply with those kinds of orders, and with supervision from community corrections or whatever. And it may well be much more appropriate and in the interests of everybody, including the public, to have that person diverted into having some support, having treatment if they've got a mental illness that needs treatment, or into some kind of support plan, which could involve NDIS involvement or a range of services. So that's what diversion is. It's instead of dealing with things in the usual way, requiring a plea, requiring a finding of guilty or not guilty, the court can instead dismiss the charge. Usually that will be subject to conditions which are enforceable for either 6 or 12 months. And it means the person doesn't have a finding of guilt and a conviction against their name. So that's what the diversionary provisions are. That's why they're important. What procedures apply in higher courts? I'm not going to spend time on that. All I need to say is that these diversionary procedures don't apply in district and Supreme Courts. In those courts, there's much more complex procedures available, and that looks at issues about whether the person is fit to be tried, whether they may be not guilty by reason of mental impairment and the like. So I think that's all I need to say for now. Thanks.
Okay, thanks, Jane. Someone's mentioned here the statistics say Section 32s are underused in New South Wales. Is this still the case? Do you know much
I would
about
think
that?
so, yeah. And remember when I was talking about the new Act, why do we need a new Act, etc., when I talked about resources, one of the main problems is there is real inequity of access. So if you want to make a Section 32 application, or what we're now calling a Section 14 application, generally you have to have a psychological or psychiatric report, something which confirms a diagnosis, and you also have to have, in most cases, a case plan, or also called a support plan, or sometimes a treatment plan. And whose responsibility is it to come up with that? It is the responsibility of the defendant or their lawyer or whoever happens to be working with them in the community. It's not like when you plead guilty to a charge and the court sends you off to either youth justice if it's the children's court, or community corrections if you're an adult, to do a background report or a sentence assessment report. And then if the court imposes a supervised order, then it's up to juvenile justice or community corrections to provide programs, etc., etc. There is none of that exists for Section 32s, except to a very, very limited extent. In quite a few local and children's courts, there are mental health court liaison workers who are employed by Justice Health. They are fantastic. They're really helpful. They can do assessments and they can help put together case plans and make referrals, but they actually can't follow through with supervising and monitoring case plans. So they can only be part of the solution, very important part, but only part of it, and they're not available to all courts. There was a pilot program called the Cognitive Impairment Diversion Program, which ran from 2017 until last year at a couple of courts. That worked with people with cognitive impairments and provided assessments and support and case plans. So for those few people who were able to access that pilot program, that provided some resources to support Section 32s. The funding for that ran out last year, but the New South Wales government in June this year announced that there would be a similar program rolled out next year, I think, in about 6 local courts. We don't know the details of that yet, but I imagine it's going to be fairly similar, or it's going to have some elements from the cognitive impairment diversion program. So the long answer to your simple question was, there are not enough resources available across the board. You can, if your case is or your matter is eligible for legal aid will sometimes fund a private psychological or psychiatric assessment, but legal aid funding is very limited. I reckon the Shopfront, maybe I shouldn't tell anyone, but Shopfront uses up a very large proportion of legal aid's budget, I think, for psych assessments. And perhaps rightly so. I think our clients are the most marginalised of anyone, almost anyone. But yeah, there's real inequity. And again, one of the things that we would have liked is a much more radical change to the legislation accompanied by resources so that everyone could have equal access to diversion.
Okay, thanks very much, Jane. That's really interesting. So this slide coming up, you're going to tell us who do the diversionary procedures cover.
Okay. So they cover, as I said, they don't apply in the district and Supreme Courts. They only apply to offences, to charges that are being finalised in the local or children's court, which we lawyers call being dealt with summarily. Now, some of you, people who are familiar with criminal procedure would know that most, I think it's probably about 90%, it's a very huge number. The vast majority of criminal charges begin and end in the local court for adults or the children's court for kids, okay? There are some charges which start off in the local and children's court, but then they end up in the district or Supreme Court because they are so serious. So if you're charged, for example, with armed robbery or wounding with intent to cause grievous bodily harm or supplying a commercial quantity of drugs, they would all be examples of offences which are strictly indictable, which mean they start in the local court, they go through some sort of filtering procedure in the local or children's court, which is called committal proceedings. There's usually negotiations between the prosecution and defence. They talk about whether maybe someone could plead guilty to lesser charges or whatever. And then eventually those charges, unless of course the prosecution decides to drop or downgrade the charges, usually those charges end up in the local, the district or Supreme Courts. So those kinds of charges, while they're still in the local court, unfortunately, the diversionary procedures don't apply to them. Even the court's ability to have someone sent to hospital for assessment, they can't do that if it's a strictly indictable charge. So the diversionary procedures only apply to matters which can actually be finalised in the local or kids court, which fortunately is the vast majority of criminal offences. Now, also, I should just say, and as the slide says, the law that the Mental Health and Cognitive Impairment Forensic Provisions Act, just like the old Act, they only apply if you're charged with an offence under New South Wales state law. Fortunately, that is the vast majority of criminal offences as well. If you are charged with a Commonwealth offence, which I'll explain in a minute, there is actually a similar procedure in the Commonwealth Crimes Act. And if we have time later on in this webinar, I'll briefly explain that as well. Commonwealth offences are typically things, well, they're offences that apply all around Australia, and typically they relate to things like taxation, social security, you know, anything to do with trade or customs, immigration, you know, importing drugs, for example, would be a Commonwealth offence. The most, at least for our clients, and I think perhaps for a lot of the people you work with, a typical Commonwealth offence is the good old use carriage service to menace, harass or offend. You make a threatening phone call, you send, you know, offensive or obscene text messages, social media posts or whatever, you could be charged with that offence. That is a typical example of a Commonwealth offence that appears a lot in local and children's courts. Social security fraud might be another one that vulnerable clients get charged with. But yeah, Commonwealth offences are not all that not all that prevalent, but there's some examples. So getting back to the state law, under the new Act, the new Section 14, which is basically the equivalent of the old Section 32, applies to someone who has a mental health impairment or a cognitive impairment. The new Section 19, which is broadly equivalent to the old Section 33, applies to somebody who, according to the Mental Health Act, is a mentally ill person or a mentally disordered person. And I think we get onto the definitions on the next slide, if I'm not mistaken. The definitions also are set out in both of those handouts.
Yeah, I don't think we have it on a slide, but we agreed that the handouts is where it's clearly outlined. So our next slide, Jane, is who doesn't the diversionary procedures cover?
And I think we've covered that. I suppose just a little bit about the definition of mental health impairment. So the definition talks about somebody who has an impairment, a disturbance in their, I think, thought, mood, etc., and that disturbance is significant for clinical diagnostic purposes. So it means that ordinary human emotions like grief or anger or sadness would not amount to a mental health impairment. It also specifically says that a mental health impairment does not include something that is solely caused by ingestion of a drug. So it would not include intoxication, even though, of course, you're going to be mentally impaired if you're off your face. It's clear it doesn't include being intoxicated. It also doesn't include a substance use disorder, which is in the DSM, and it's often referred to in psych reports as a mental illness or mental disorder. But if it's solely a substance use disorder, then that is not considered a mental health impairment. I think also if it's a drug-induced psychosis, it's not a mental health impairment either. But let me say something about drug-induced psychosis, because I think that term is used a bit loosely and I think sometimes incorrectly. The sort of drug-induced psychosis that would be excluded would be you take too much ice or speed and you immediately become psychotic, but remove the drug, stop taking the drug, and that psychosis resolves usually quite quickly, usually in a few days. That is a true drug-induced psychosis, and it's caused solely by the ingestion of a drug. But quite often I see or hear the term drug-induced psychosis to actually refer to a more long-term psychotic illness, which actually doesn't go away once a person has stopped taking drugs. So somebody with a predisposition towards schizophrenia, for example, who might smoke a lot of cannabis, and that schizophrenic illness may be triggered earlier than it otherwise would be by the use of excessive use of cannabis. I have often heard that kind of mental illness referred to as drug-induced psychosis, when it's actually a long-term and enduring psychotic illness. So that kind of illness, any kind of long-term psychotic illness would be included. Also, in my view, personality disorders, there's often debate or controversy about whether a personality disorder is a mental illness. In my view, there are a lot of personality disorders which do cause very serious disturbance in mood or thought or volition. They do come within the definition of mental health impairment if they do cause those sort of serious disturbances.
Okay, thanks.
They also cover, so cognitive impairment, I don't want to say too much more about that, but the definition of cognitive impairment is set out. It quite clearly includes, it now includes, as well as intellectual disabilities, it includes people who have a cognitive impairment due to things like acquired brain injury, dementia, autism spectrum disorder, and the like. So I'll leave it there.
Okay. So now we're looking at the old and the new, what changed and which one applies now. Do you want to just do a quick overview of that?
The old and the new Act, at least as far as the diversionary provisions are concerned, they're actually running, they're both running alongside each other at the moment. So if you are in court, if the criminal charges were laid before the 27th of March this year, and there's a lot of matters still working their way through the local and children's courts where the charges were laid before then, the old Section 32 and 33 still applies, okay? So we're still making Section 32 applications, and we will be doing so for quite a while. But if the charge was laid on or after the 27th of March, then it is the new Act that applies.
Okay.
So that's all I need to say. And what has changed is next.
Yeah, so talking about the new Section 32 or Part 2, Division 2 of the new Act, what has changed?
All right, so I guess this assumes that most of you will have some familiarity with the old Section 32. If you don't, hopefully there'll be an opportunity to ask questions or for me to explain. But as I said, the most significant thing is that everything's been renumbered. Final orders are now in Section 14, so we generally talk about a Section 14 application. Eligibility criteria are very similar, but there are slightly different definitions. So the old Section 32 applies to someone with a cognitive impairment or a mental illness or a mental condition for which treatment is available in a mental health facility. Now, the new Act applies to, again, cognitive impairment, but instead of mental illness and mental condition, it's been brought together into this new definition of mental health impairment. So the definitions are a little bit different and hopefully clearer. Now, another fairly significant change is that an order under Section 32 is only enforceable for up to 6 months, okay? So if you're discharged subject to conditions and you breach those conditions, like you just disengage from your treatment or case plan, you could, at any time within 6 months after the order, you can be brought back to court and the court can decide to deal with the charges all over again or whatever they want to do. that period has been extended to 12 months. Now, it's often thought, a lot of magistrates have been reluctant to deal with matters under Section 32 because they've said, oh, well, it's only enforceable for 6 months and that's not long enough. I personally think that's a little bit of a, I'm trying to be polite. It's a little bit of a spurious reason for refusing a Section 32 because the court has always had the power to adjourn proceedings. So if they want the person to demonstrate compliance with a case plan over a longer period, there is absolutely nothing to stop the magistrate from adjourning the case for like 3 months or 6 months or however long they want, to see if the person is willing and able to stick to the case plan and to see how they go. So they could adjourn it for 6 months, and then if they're satisfied that the person seems to be making progress, then they can finalise that under Section 32. So I think magistrates saying, oh no, it's inappropriate because 6 months is not long enough, I actually think that's just an excuse. But there are many people who think that making it enforceable for up to 12 months might persuade more magistrates to dismiss matters. Let's see. I don't know if that will happen or not.
Yeah. Okay. And I'll also let our audience know that Legal Aid New South Wales has a new easy English fact sheet about Section 14s, which was developed with the Intellectual Rights Legal Service. So a link to that resource, which is available on our publications fact sheets page on our website, but there's a link in the email following this webinar.
Yeah,
So,
there's also a link in my handout. I think that it's a very simple, aimed at people with cognitive impairments, very, very simple plain English fact sheet aimed at aimed at that client group. Okay.
Great. So what hasn't changed with Section 32, Section
Right.
14?
So what hasn't changed is, as I said, the court can make interim orders if they want, so they can adjourn proceedings and make temporary orders, or they can make final orders. An order under either Section 32 or Section 14 can be made at any stage of the proceedings. The Act clearly says, and particularly the new Act is clearer than the old Act on this, the new Act clearly says that the defendant cannot be required to enter a plea, and more particularly, they can't be made to incriminate themselves, right? So they can't be made to admit to the offence or whatever, right? They do not have to enter a plea or admit to anything. But if they have entered a plea, or even if they've been found guilty at a hearing, Section 32 or Section 14 is still available, okay? So it can be used at any stage, whether or not a plea has been entered. Now, if the kind of final orders that the court can make are much the same under the old Section 32 and the new Section 14. So the court can dismiss the charge unconditionally, which is quite rare, but it is possible. It actually happened the other day in a matter that I had, where this young woman had been charged with breaking a door at her mum's place, and also assaulting her mum by slamming the door, and her mum happened to be on the other side of the door and got clocked with the door. She didn't get any injuries, so it was a common assault. It was actually over a year since the alleged offences. There'd been a lot of delays in the court. This was a young woman. She'd had no prior criminal history. She was only 18. She has some quite significant mental health issues. She's been engaged in treatment for a long, long time. She's improved so much that she'd just been discharged from the community mental health service that was working with her because they thought she didn't meet their criteria anymore because she was better. And I persuaded the court. I said, look, we don't have a case plan going forward because she's done so well. Look at the length of time that's elapsed since the alleged offences. There's been no offending before or since. This would be appropriate. What are you going to do if she pleaded guilty? What sort of punishment she's going to get? She might have them dismissed without a conviction under Section 10, for example. So why don't you dismiss it unconditionally? And the magistrate accepted that. If somebody was charged maybe with a very minor drug possession offence, or like trespassing or disobeying a police move on direction or something like that, the kind of thing that you would often get or shoplifting, kind of thing that you would often get a Section 10 dismissal for, or a caution if you're in the children's court, that's the kind of thing that might get you an unconditional dismissal. Mostly though, the court is going to dismiss the charge and discharge the person into the care of a responsible person, either unconditionally, but usually subject to conditions, or instead of nominating a specific responsible person, they could discharge the person on the condition that they attend a particular place or person for assessment or treatment. So they could say, okay, you have to attend Camperdown Community Mental Health Centre, or you have to go and see your GP or your NDIS support coordinator or whatever. Now, it's important that a final order, it doesn't amount to a finding of guilt. It doesn't amount to a finding of not guilty either. It's diversionary, so it kind of sidesteps the issue of whether you're guilty or not guilty. Importantly, it doesn't amount to a conviction, so it does not end up on your criminal record. So if you're required to disclose criminal records for a job or whatever, you don't have to disclose that. However, the court will have a record of it. So if you come back to court for other charges and you're making another Section 14 or Section 32 application, the record will show that you have been dealt with in that way in the past. Okay, thanks, Kerry.
Okay, thank you. All right, well, let's look now at that Section 33, Part 2, okay. Division 3 of the new Act. What's changed with those?
All right, so Section 33, firstly, just what's the difference between 32 and 33? So Section 32 applies, as I said, if Section 32 and the new Section 14 applies to someone with a mental health impairment or a cognitive impairment who is generally okay to be out in the community. Section 33 or the new Section 19 applies to someone who is according to the Mental Health Act, a mentally ill person. What that means is someone who has a mental illness and due to that illness, they need care, treatment or control for either to protect for their own protection or for others' protection from serious harm. So in other words, they're people who would meet the criteria for involuntary admission to hospital or would meet the criteria for the making of a community treatment order. Okay, so they're people who are very unwell. Now, the old Section 33 applied to a person who is a mentally ill person. And it allowed, as well as allowing the court to make final orders dismissing the charge, it also gave the court the power to send somebody to hospital against their will to be assessed, and if they were found to meet the criteria for admission, they could be admitted to hospital for treatment, okay? Now, the difference, really the only difference between the old and new, apart from the numbering, is that the new Section 19, as well as applying to a mentally ill person, it now applies to a mentally disordered person. Now, people who are familiar with the Mental Health Act and with people being involuntarily admitted to hospital would understand that a mentally disordered person is someone who may or may not have a mental illness, but who needs care, treatment or control for their own or others' protection from serious physical harm. Typical example is a person who is suicidal or who is self-harming in a really serious way. So they might not have an underlying mental illness, or maybe they've never been diagnosed and no one knows whether they do or not, but they're presenting with behaviours which are causing a really serious risk to either themselves or to others. So that's a mentally disordered person. Now, under the Mental Health Act, they can be admitted to hospital, but for a more limited period than a mentally ill person. Under the new Mental Health and Cognitive Impairment Forensic Provisions Act, a mentally disordered person can be dealt with in the same way as a mentally ill person. So they could be sent to hospital by the court.
Okay. So what hasn't changed then in terms of Section 33s, Jane?
Okay. So as with the Section 32 or Section 14, Section 19, Section 33 or Section 19, the court has a range of orders available to them, final or interim orders. The person doesn't have to enter a plea. An order can be made at any stage during proceedings. The orders that the court can make are the most common type of order is to send somebody to hospital, and they may or may not come back to court. Sometimes they can be sent to hospital, they can stay there for quite a long time, and the matter is deemed to be finalised and the charge is dismissed, and that's the end of it. They can also discharge the defendant into the care of a responsible person like they can with a Section 32. In some cases, the court can make a community treatment order, but only if there's a community mental health team who's willing to accept a person on a CTO and has a case plan and whatever. Now, with Section 33 and also with the new Section 19, it's enforceable for up to 6 months. So with the new Section 14, the enforcement period has been increased from 6 months to 12 months, but with the new Section 19, for whatever reason, I don't know, they've just stuck with the 6-month period. So okay. That is what has and hasn't changed there. Great.
All right, so I don't think we've got any specific questions. Someone did mention that some lawyers, some magistrates persuade the lawyer to obtain instructions from a client with mental health condition to enter a plea before a Section 14 is heard. They're worried about incrimination. Is there a way around this not to enter a plea? But you were saying...
You just have to insist. I mean, this as a lawyer, I guess it's a test of your advocacy skills. Under the new Act, you can point the magistrate to the specific section. I can't tell you what section number it is, but it's there. There is a specific section that says the defendant does not need to enter a plea. You can go off on a rant about how this is intended to be diversionary and yada, yada, yada. If you are pressed to enter a plea, I would generally enter a plea of not guilty if I'm in any doubt about the client's understanding of the charges, their fitness to be tried or whatever. I would err on the side of caution and enter a plea of not guilty. But I think it's helpful to understand that a main reason, big reason why magistrates are pressing people to enter pleas, it's all about case management, right? And management of their lists. So the local court magistrates are under a lot of pressure to move cases on and to finalise cases. And I think that pressure is just getting worse and worse given the backlogs in courts caused by COVID and matters having to be abandoned and relisted and whatever. So I think magistrates feel under a lot of pressure there. And I think the rationale is, well, okay, say I list this matter for a Section 32 or a Section 14 application in 6 weeks' time. That application is unsuccessful or it doesn't proceed for whatever reason. Well, now we're back to square one. They haven't entered a plea yet. We've just wasted 6 weeks. Now, 6 weeks down the track, they tell us they want to plead not guilty. So now we've got to adjourn it for another 6 weeks to get the brief of evidence. And then we have to adjourn it for God knows how many months to the actual hearing date. So I think what the courts are trying to do, but unfortunately, I think some magistrates maybe don't express it clearly enough, or lawyers misunderstand. I think what the courts are trying to do is say, hey, okay, let's be practical here. If this Section 32 or Section 14 application doesn't end up proceeding or is not successful, how are you going to plead? Because if you're going to be pleading not guilty, how about we make orders for the police to serve the brief now, and that way, if the application fails, we haven't wasted all this time, and then we can set a hearing date. So that's usually the rationale. There are 1 or 2 magistrates who take the view that, oh, well, if you're pleading not guilty, then you have to run the hearing first so that we know what the facts are. Or you have to enter a plea, or you have to admit to the facts first, because I need to know, you know, we need to know what the facts are that we're making the application on. With respect, that's bollocks. That's just an erroneous view of the law and of the idea of diversion. The magistrate will read the police fact sheet, so they'll see what the allegations are. Occasionally, we might hand up other evidence. Usually a Section 32 or Section 14 application proceeds based on the police fact sheet, which I guess is the allegations at their highest. I ran a Section 32 application not long ago on behalf of a young woman. Again, it was another incident with her mother, where I think she's a young woman with little or no prior convictions, a pretty stormy relationship with her mum. Mum came to the house. This young woman actually lives with dad. Mum came to the house where she doesn't even live. She came to dad's house, started sort of like storming around, telling the girls to clean their rooms and laying down the law. There was a verbal argument where I think they were in the kitchen, and the young woman, my client, was holding I think she had a glass or a drink bottle or something like that, and she smashed the bottle or the glass on the kitchen bench. Mum claimed to have been intimidated by that, thought that the daughter was, smashing this glass on purpose to threaten the mum or whatever. So the allegations taken at their highest were that the daughter had threatened the mum, had smashed this glass, the implication being that maybe she was intending to use it as a weapon or intimidate her in some way. There were statements taken though from, I think there were two sisters, there was a friend, there was the dad. They all painted a very different picture from the mum. And so when you took all of those statements in context, you could see that mum was really exaggerating, and these supposed threats that the daughter had uttered to the mum, it turns out had not been made at all. So I actually handed up the statements from the other witnesses, and I said, to the court, you need to take into account that the police facts are not necessarily the whole story, and that diminishes the seriousness of the alleged offence, and in fact it probably means she hasn't even committed an offence at all. And the magistrate accepted that and dismissed the charge under Section 32. So I think that's an example of where, a rigid approach to entering pleas and to sort of trying to decide what the facts are has to be resisted.
Someone asked, Jane, is there any new case law or insights from practice around these sections that would be useful to be aware of?
Not yet, not that I know of. I guess there will probably be some new case law coming soon. If you are interested in case law and in a more detailed paper about these provisions, if you go to, there's a website called Criminal CPD. It's criminalcpd.net.au, and it's aimed at lawyers. If you go to the mental health page of that website, you will find a paper that I've written called "What's New with Section 32," and the latest version was May 2021. Now that refers to a whole lot of case law about the old Section 32 and 33. And in my view, because the law hasn't changed all that much from one act to the other, in my view, most of that case law is still relevant. And it's also got some discussion of like whether psychologists can disclose mental health impairments, because there are some people who think you've got to have a psychiatrist. There's all sorts of stuff in there. So if you are interested in case law or a sort of a more like dense and lawyerly kind of discussion, please go and have a look at that paper.
Okay, thank you. Someone's asked about if there's a breach, who do you report it to, or how do you define a breach?
Yeah, okay, that's a really good question, actually. There's something about that in the handout.
Okay.
Well, unhelpfully, in the Act, and it's the same provision in the old and the new Act, and they didn't take up the opportunity to fix it, which is a bit dumb. There's a section that says that a treatment provider may report a breach to community corrections, youth justice, or to another body prescribed by the regulations. And to my knowledge, there's no regulations prescribing that. Now, why that's dumb is because community corrections and youth justice, or juvenile justice, whatever you want to call them, they don't have any role in supervising Section 32 or 33 or 14 or 19 orders. Unlike things like good behaviour bonds, parole, community correction orders or whatever, they have no role at all. So why would you report a breach of a Section 32 order to a probation or a juvenile justice officer? Well, you wouldn't, okay? So in practice, and also it may not just be a treatment provider who wants to report a breach. It might be the responsible person who's not a treatment provider, but who's a caseworker who's sort of supervising the case plan. So in practice, say you are somebody who has agreed to be the responsible person on an order. So you may be a caseworker, you may be basically just supervising, supporting the client to make sure that they attend their appointments, keep complying with their medication. If they're on medication, you may be making referrals to other services, etc., etc. So if you're the responsible person and you believe the client, the client has disengaged, or if they've committed a fairly serious breach, like they're just suddenly refusing to go and see their counsellor or refusing to take their medication and they've got a really serious mental illness or whatever, what you would generally do is report a breach directly to the court. So you'd probably send an email to the court just setting out the circumstances. It's really important to understand that there's actually no legal obligation to report a breach. There is protection if you are a treatment provider or worker and you think you need to report a breach. The law offers you some protection against actions from your client for breach of confidentiality, for example. Okay, so you can report a breach knowing that the client doesn't really have any comeback against you for breaching their confidentiality, but you don't have to. Sometimes you may have a duty to report it. So say you've agreed to be the responsible person and you're actually in court with the client and the magistrate says, well, so-and-so caseworker, as the responsible person, will you undertake, meaning will you promise to the court that if Michelle doesn't comply with these conditions, that you will report to the court? And it doesn't happen very often, but there are some magistrates who are reluctant to dismiss matters without that kind of undertaking or promise from the responsible person. So if you are a responsible person and you've made an undertaking to the court, then yes, I think you do have a duty to follow through with that. And if the client breaches the order, you would report it. But if you haven't made that undertaking, then really it's up to you. Even if you have made an undertaking, the court's not interested in minor breaches, like, the client misses 1 or 2 appointments. They're not going to be interested in that. It's really only if they've completely disengaged or they're not complying with a pretty fundamental plank of their case plan. And if there is a breach, so if a caseworker or treatment provider or whoever reports a breach, then the court generally, I don't know, sometimes the magistrate might just call for further information from the caseworker or whatever. Sometimes they may relist the matter and they'll call on the defendant to appear again. In most cases, I mean, breaches are very, very rare. I've been running Section 32 applications for God knows how long, like more than 20 years. And I've seen probably like less than 5 breaches in all of those years, okay? Very rare. And usually the court is not really interested in sort of escalating things and starting the case all over again and punishing the person. Usually they're interested in making sure that the person gets back on track with the case plan and allowing the Section 32 order to continue. So that's...
Thank you, Jane. I'm just conscious that it's 2 o'clock, so we've probably got about 10 minutes left of our webinar. So if people need to go, just a reminder that it is being recorded and it will go up on the Legal Aid New South Wales YouTube channel, probably early next week. So we can send you the link to that. I think the next slide was just to look at those Commonwealth offences, Jane. You wanted to just quickly look at that.
So just briefly, Commonwealth offences, which you don't get all that many of in the local and the children's courts. There's a similar diversionary procedure, which is Section 20BQ of the Commonwealth Crimes Act. It applies to a person with a mental illness, and the meaning of mental illness is pegged to the relevant state law. So it would be the definition of mental illness from the Mental Health Act, or an intellectual disability. So technically it may not apply to someone who's got a cognitive impairment which is due to dementia or an acquired brain injury, unless they also have a mental illness. The orders they can make are very similar to a Section 32 or Section 14 order. A big difference is that it's up to the court to decide how long they want it to be enforceable for. So the court can specify a period. So they can say, I'm making an order under Section 20BQ for 12 months. And they can make that for any time up to 3 years. So it's actually potentially, it can be enforceable for quite a long time if the court chooses. Now, there's actually no Commonwealth equivalent to Section 33 or Section 19. So it seems there's no power under the Commonwealth law to send a person to hospital, which is a bit of a deficiency. I don't know if there's any proposal for law reform around Section 20BQ because it hasn't been looked at for quite a long time. It would seem that it's probably right for review, but I don't know if that will happen ever.
Okay. Thank you. So next slide coming up, Jane. Very important question. How can community workers help their clients who have mental or cognitive impairments in the criminal justice system?
Okay. Well, getting legal help early is an obvious one. So helping your client to access legal aid, if that's the service for them, or the ALS, or maybe the Shopfront or Intellectual Disability Rights Service, or whoever. Also, I guess, with the client's consent, of course, getting involved in the discussions between the client and the lawyer and making sure the lawyer actually does know that the client has a cognitive impairment or a mental health issue. Because if you're a busy legal aid duty solicitor, you might not pick that up from one interview with a client. You may not pick that up. You may not have enough time to really delve into things or to sort of read the signs or to become aware, and the client might not volunteer that information either because they don't identify as having a disability, or there's stigma, or they don't think it's relevant. So with the client's consent, of course, making sure the lawyer is aware is a really important thing. The Justice Advocacy Service, so that is a really good support service for people with cognitive impairments. It's run out of the Intellectual Disability Rights Service. It provides support people for people with cognitive impairments, not only in court, but at police stations and other kinds of settings. So, I mean, maybe if you're a support worker and you're going to be going to court with the client anyway and supporting them quite closely, they may not need the Justice Advocacy Service, but otherwise it's a really, it's a good service. I'd commend them to you. If it's a person with a mental health impairment and they're at a court where the Justice Health Court Liaison service is available, then helping with a referral to Justice Health would be really useful. Often the lawyer will do that, but sometimes the client might be unrepresented or need a little bit of help along the way. Helping prepare case plans and letters to the court, agreeing to be the responsible person can be enormously helpful. And also, of course, if and when the matter is dismissed under Section 32 or 14 or whatever, helping the client to comply with the orders is a big one as well.
Someone asked earlier, Jane, about how it seems unfair that there's this cost imposed on the client for getting psych reports and paying for lawyers. What sort of help can community workers do in that sort of area, do you think?
Well, I suppose trying to source reports from existing service providers or relying on existing material. So if you've got a client who has a very long psychiatric history, you know, and they've been in and out of hospital, they might be under the care of a community mental health team. In many cases, we can actually use, you know, their records like discharge summaries from hospital admissions to establish that they have a diagnosis of schizophrenia, for example. We can get letters from their current treatment team, which sets out their history and diagnosis and whatever. Different community mental health teams have very differing requirements. Officially, I think none of them are really allowed to do court reports, but quite a lot of them will do support letters. Some of them will do reports if you go through the medico-legal department, and which is very tedious. There might be a fee, but it's smaller than you would have to pay for a private assessment. So getting things from existing sources if you can, using the Justice Health Court Liaison service if the issue is mental health rather than cognitive impairment, and if that service is available, that's free. Otherwise, trying to help a client with a legal aid application and advocating for legal aid to pay for a private assessment. Those are some of the things. I mean, also, if you work in a youth service, or maybe not just a youth service, but these are the only ones we know. I mean, our clients can get access to brokerage funding for certain things. So if you work for a service which has access to one of those brokerage programs, you might be able to hit up the brokerage fund to pay or to help pay for an assessment. So I guess also if you've got a client who's eligible for NDIS, you may be able to get stuff from them as well. I guess just sort of being flexible. But yeah, it is really inequitable if you're not eligible for legal aid for whatever reason, yet you can't afford a private assessment. It's inequitable, and I've got no answer to that.
Okay. All right. Well, the slide that's coming up now is just a summary of the services that Jane's spoken about that can help with clients in the criminal justice system, and the contacts for these services are all in the email that's coming after the webinar. So the Justice Advocacy Service, the Justice Health Court Liaison, and the link takes you to the page which explains which courts they're present in, Legal Aid New South Wales, the Aboriginal Legal Service, and for young people under 18, the Legal Aid New South Wales Youth Hotline, and the Shopfront Youth Legal Centre, which of course Jane works for, and the Intellectual Disability Rights Centre, which runs the Justice Advocacy Service. So I think that brings us right to the end of our webinar. And Jane, question here, would PTSD from domestic violence trauma be considered a cognitive impairment?
I would say PTSD is a mental health impairment. So yeah, not a cognitive impairment. I would say mental health impairment for sure.
Okay. And
as long as it meets, again, as long as it's clinically significant. So if it really is PTSD, you know, with all of those symptoms, then yes, definitely.
Okay. And someone asked a little bit earlier about your criminal record, but I think you mentioned that. But if you want to say again, what is it? What record does it go on?
Well, it doesn't form part of your, it's not a conviction, and it doesn't form part of your criminal record. However, it will appear on what's sometimes called your criminal history. Criminal history is basically a document which has got everything that you've ever been charged with. So say the police have charged you with something and they've decided to withdraw the charge because they realise there's not enough evidence to support it. That will still go on your criminal history. That's the kind of document that the police have access to and that courts will have access to in certain circumstances. So, but yeah, just because something's on your criminal history, it doesn't mean it's a conviction and it doesn't mean it's part of your criminal record.
Mm. So if they did a police check for employment, for example, it wouldn't show up there?
No.
No.
And
All
if
right.
it does, there's something really wrong and you'd need to talk to a lawyer and complain.
Okay. Well, I don't think there's any other questions that have come up. So that brings us to the end of our webinar. Thanks for everyone's participation today. And of course, thank you, Jane, for sharing all your knowledge in this area. And if you're watching this webinar as a recording and you have any questions, you can send those to cle@legalaid.newsouthwales.gov.au.
You could also send questions if you want to the Shopfront, Shopfront at theshopfront.org. I think our email address, or it's easily available on our website or at the bottom of that handout as well.
Yes. So whilst we've still got the webinar open, if you haven't already, please download those 2 handouts so that you have those for future reference. And just a reminder that you'll get a feedback survey. We really appreciate that, as well as that email with those links. And because we've gone over time a little bit, I'll also send out an email next week to everyone who attended today with a link to the recording and also those handouts. So we're just getting some feedback saying, well done, thank you very much, very comprehensive. I think some of our participants have worked with you over the years, Jane. They're also saying, nice to see you again. All right, well, that's it, I think. So thanks again, Jane. We really appreciate your time today, sharing your knowledge and answering our audience's questions. So we'll end the webinar now, and we look forward to seeing you at our next Law for Community Workers webinar. There's quite a few coming up over the month of October. So I'll end the webinar now for everybody.
Okay.
Okay.
All right.
Bye.
Bye.